Hi, my name is Chris Bavitz, and I work with the team at the Cyberlaw Clinic, which is the Technology Law and Policy Clinic at HLS. We're going to speak with you today about the clinic and more generally about how we think about practicing and teaching tech law while centering a core set of values and ensuring that our work advances the pursuit of social justice. For more information about the clinic and our practice, you can find us on Twitter and Facebook and on the web at clinic.cyber.harvard.edu. And you should please feel free to reach out to any of us on the clinic team if you have any questions. The Cyberlaw Clinic was founded in 1999, and we commemorated our 20th anniversary during the 2019-2020 academic year. The arc of the clinic's past 2 decades of teaching and practice in many ways tracks the arc of the widespread adoption of internet technologies. Not surprisingly, the earliest days of the clinic's docket included a lot of copyright matters, reflecting the fact that the impact of the World Wide Web was felt perhaps most acutely and most immediately in the realm of content creation and distribution. These days, the clinic works on a broad range of substantive legal issues. We've resisted the urge to specialize, and we do our best every semester to have projects in most, if not all, of the issue areas reflected here. We continue to work on copyright matters, advising those who create and use expressive works, text, images, video, music, and software code about their rights and responsibilities, and helping individuals and institutions to advance their copyright policy goals. Other highlights from our substantive docket include projects that focus on the development and deployment of technologies incorporating artificial intelligence and machine learning, and specifically addressing concerns about opacity and bias. We advise our clients on matters relating to consumer protection, privacy, and compliance, with a note that we consider individuals' rights to privacy vis-a-vis both government and private corporate actors. We support thoughtful government innovation, reflecting our commitment to ensuring that municipal, state, and federal institutions that adopt technology do so with care. And we have a variety of initiatives and client projects that focus on the US First Amendment right to free speech and on the broader global right to free expression. We have similarly endeavored to do different types of work, including transactional work, advising, litigation, policy advocacy, and public education and engagement. The clients with which we work have a broad range of needs, and we're committed to helping our students develop the multifaceted skill sets required to help clients achieve their goals as they build technology and seek to influence the development of tech policy in the US and around the world. Sometimes the very same client might come to us with a question about the terms of an open source software license while seeking an internal risk assessment about its development of a new piece of code that might implicate third parties' rights. And at the same time, looking to create some sort of public-facing toolkit or dashboard to help others in their field navigate hard legal questions. And we try to be prepared to do all of these things and to think carefully about the ways in which those different component legal projects fit together. Pulling back from the specific work of the clinic, many of the most pressing problems and concerns in the broad field of technology law are interdisciplinary, and many also require engagement with a number of private and public actors in order to maximize impact. A lot of legal advocacy focuses on the role of federal courts and on the development of precedent that can inform future judicial decisions. In our clinic, we regularly have to look beyond traditional litigation-oriented approaches. We think carefully in each project that we take on about the various modes of engagement we can pursue and about the many levers that we have at our disposal to affect change and advance the clinic's and our clients' interests. For example, much work in our field involves attempting to influence the practices of large private companies, platforms that host content and mediate a lot of our online activities. The market for qualified labor in tech is tight, which means that tech company employees wield significant power and have emerged as vital forces for change. Federal law is undoubtedly important with respect to the regulation of technology, for example, regarding the protection of intellectual property and the use of works that are subjects of patent or copyright protection. But state and local law is crucial, often paramount, when it comes to issues ranging from anti-discrimination to privacy to consumer protection. County and municipal bodies, as well as state courts, state attorneys general, and state legislatures are often on the front lines, and many of our clients have a strong interest in engaging with and influencing the development of law and enforcement priorities at the state and local level. Finally, global multi-stakeholder organizations that include private entities working alongside representatives from academia and civil society can have a profound influence on how companies do business in a networked world. We work hard to give our students a holistic sense of this landscape through their clinic work. In general, the Cyberlaw Clinic does not do work or take positions on policy matters in its own name. We generally take on projects with and on behalf of clients or in collaboration with partners seeking to advance their own interests and agendas. That said, the clinic has developed a set of values that we consider in connection with all of our client intake and project scoping efforts. The values include promotion of a robust and inclusive online ecosystem for free expression, elimination or mitigation of the impact of bias in the development and deployment of technology, and access to knowledge and information. We're explicit about these values, and we regularly revisit them to ensure they reflect our orientation to the issues that are subjects of our work. And we speak regularly with students about the challenges associated with advocating for clients' interests, as we're required to do under relevant rules of professional conduct, while maintaining our own explicit principles that guide our approach to legal representation. The clinic's clients and collaborators run the gamut from individual activists, advocates, and developers, many of whom are drawn from the research community at the Berkman Klein Center for Internet and Society, where the clinic was founded, to nonprofit and other mission-driven startups, to NGOs and advocacy groups, to news media outlets, and other creators. The clinic considers a variety of factors when selecting clients and projects, including how well the clients and their needs mesh with our own statement of values, the ability of a client to access services elsewhere, and the likelihood that we can scope a particular project or question in a way that leverages our expertise, is useful for the client, and provides an enriching pedagogical opportunity for our students. On that note, let's hear from some members of the clinic team to talk about their work.
Hi, my name is Jessica Field, and I'm the Assistant Director at the Cyberlaw Clinic here at HLS. Delighted to be joining you for J-Term via video. And I wanted to just talk a little bit about my practice and how it intersects with social justice and the public interest, because in contrast to some of the other clinics around HLS, it's not always perfectly transparent to people how tech law practice can be a social justice practice. So my work divides roughly into two buckets. The first is around digital arts and media. And this is the work that I actually came to the clinic doing. Previously, I had been in-house at WGBH, which is the Boston public media station. It also produces about a third of the content for PBS nationwide, so the largest single producer of PBS content. So while I was there, I did a lot of copyright work, as well as sort of general entertainment law work, contracts, etc. I'm mostly a transactional lawyer. I've done very little litigation over the course of my career. And at the Cyberlaw Clinic, what that digital arts and media practice looks like is advising artists and nonprofits on, for example, fair use questions that come up with regard to their innovative projects. We've had a bunch of cool stuff around the use of artificial intelligence technologies in art in recent years, as well as a lot of stuff around digital archives. What does it mean when work is preserved in large quantities online and made accessible? That raises lots of interesting copyright questions. And finally, we do some contract law for those clients, particularly like terms of use around innovative online projects. The second bucket of my work is technology and human rights. And I inherited this from another colleague of ours who has left to head up a similar clinic at the University of Ottawa. And it had always been an area of interest for me since law school. So I've been very glad to kind of take it over and shepherd it forward. But our work in tech and human rights typically looks like collaborations with NGOs or nonprofits domestically here who have needs beyond what they can do in-house. So that might look like a huge background memo for a big NGO that helps them explore how they might use competition law to provide remedy for human rights harms. Or it might look, as it did this past year in a shortly forthcoming paper, like research in collaboration with the International Human Rights Clinic on the impact of internet shutdowns on Rohingya Muslims on both sides of the border in Myanmar and in Bangladesh. And so that work has been really fascinating for me and really sustaining. And I think that you'll find if you join us at the Cyberlaw Clinic and in watching my colleagues' videos that our work really does impact economic, racial, and other social justice matters across the board.
Hi, my name is Mason Courts, and I'm one of the clinical instructors at the Cyberlaw Clinic. Like my other clinical colleagues, I'm a bit of a generalist, but today I wanted to talk about a few areas of the law that are particularly interesting to me that I think intersect particularly well with the clinic's social justice mission. One of those areas is my work in civil liberties and civil rights. Before coming to the clinic, I worked at the ACLU of Massachusetts, where I did a lot of work on issues like free speech, privacy, equal protection, religious freedom, and separation of church and state. Carried over some of that work now that I've come to the clinic, although now it's in the context of technology. So, for example, with free speech, we're looking a lot at freedom of speech in an online environment. Regarding privacy, we often look at privacy in regards to what you might call high-tech invasions of privacy through things like drone footage, biometrics, or tracking people based on their cell phone location. Like the work I did at the ACLU, a lot of this focuses on government invasions of these rights. So we look at government regulations of free speech. We look at government use of technology to conduct searches or seizures. And we look at how uses of technology impact people equally or unequally. This work all intersects very well with the social justice mission of the clinic, as unfortunately and probably unsurprisingly, it's often racial, religious, or ethnic minorities, gender minorities, or people living in poverty or who are otherwise traditionally disempowered who are first and most highly affected by government intrusions on their civil rights. One thing that's a little bit different about the work that I do for the clinic is that we don't solely focus on intrusion of these rights by government actors. In the modern sphere of technology, there's a lot of concern about intrusion of traditionally government-facing civil rights and civil liberties being affected by private actors. When you have organizations like Facebook or Amazon or Google that are capable of regulating and even manipulating the sphere of speech online, or that have the power and the interest to do things like invade the privacy of their employees and their users, there's a lot of concern that the types of rights that we traditionally think about as being protected vis-a-vis the government are also need to be protected vis-a-vis private actors. Of course, that gets more difficult because the Constitution only applies against government actors. So we're often looking not at constitutional causes of action, but things like civil rights statutes, labor relations statutes, state laws on eavesdropping, and even sometimes things like laws on consumer protection that might categorize some of these invasions of rights as unfair business practices. So this, the work I've done with the clinic has caused me to really stretch what I think of as the classic civil rights and civil liberties framework to include non-government actors and to include very, sometimes novel causes of action. It's been really interesting work, and I've really enjoyed working with my students on that front. The types of work we do there, a lot of our work is appellate litigation, specifically amicus briefs, which we often write in important civil rights cases at the federal circuits or the Supreme Court, and a few that we've done at other levels. For example, we recently did one, we recently wrote a brief on the admissibility of probabilistic genotyping evidence at a New Jersey appellate court. We also work closely with more traditional civil rights and civil liberties organizations like the ACLU, Center for Democracy and Technology, Upturn, a lot of organizations that are particularly interested in the intersection between technology and civil rights. In those cases, we often act as advisors, exploring potential areas of litigation or areas of statutory reform that these organizations are considering pursuing but don't have the resources to fully explore themselves. In that case, often what we'll produce is a detailed legal memo along with advice on how the organization could proceed, and sometimes even things like model statutory language, or draft legal arguments. The other area I wanted to talk about that's become a big part of my practice is freedom of information work. The Federal Freedom of Information Act and its state counterparts are a great way for individuals to get access to government records and find out what their government is doing. Unfortunately, there's often a lot of resistance by the government to turning over records, partially because it's an administrative burden and partially because there may be stuff in those records that prove that they're not doing their jobs correctly and they would rather not release that information. For the last few years, a lot of the work that I've done has been helping people draft freedom of information requests and manage them as they come in. We've also done some appellate litigation around freedom of information requests, again, mainly as writing amicus briefs in some very interesting cases that have to do with access to records that are stored in databases. More recently, we've actually started doing direct client representation under the Freedom of Information Act. So we have a few suits that are pending in federal court where we are suing various government agencies because they either did not correctly produce records or they miscategorized our clients as commercial requesters when in fact they are educational requesters, various other issues related to government transparency and access to records. Most of our work is under the Federal Freedom of Information Act, although we've also done some work with partner organizations like Muckrock Incorporated on state access to state records under state public records laws. So those are just two of the areas that I work in that have intersection with social justice. Again, most of the clients we work with are either organizations that have their own stated public interest and social justice goals, or we work with individuals who otherwise wouldn't be able to afford legal representation, pursue their goals. When it comes to the Freedom of Information Act work, a lot of the folks that we work with are individuals who are concerned about what their government is doing, but don't have the expertise to navigate that system themselves or the resources to hire a lawyer who's going to be charging them several $100s an hour. So a free resource like the clinic is really important to these people. And with the civil rights and civil liberties work that we do, there's a strong and clear connection to social justice there. We're just looking at it through a specific lens of how technology affects those rights. And we're able to bring together our expertise and our interest in technology with our interest in advancing social justice by protecting the rights specifically of traditionally disenfranchised groups. So really looking forward to talking with you all more about this and hope that you found this informative. Thank you.
Hi there, my name is Kendra Albert and I'm a clinical instructor at the Cyberlaw Clinic. And I think of my work as serving the public interest in a couple of different ways, as aligned with various parts of my practice. One of the ways in which I see myself doing public interest work is demystifying the legal system on behalf of actors who don't necessarily always have access to counsel. My sort of best example of this is my work with Hacking Hustling, a sex worker organizing collective out of New York that bridges traditional gaps between sex working communities and folks involved in the sex trade and technology policy. And for Hacking Hustling, we've both done work within the context of the clinic, but I also do sort of work more broadly around providing help understanding technology law and technology policy as a legal advisor. The next sort of category of public interest work I do is counseling folks who are doing research or building tools that move forward the public interest on technology law issues. This can range from anything from sort of individual academic researchers, including Nate Matias's Citizens and Technology Lab, which runs citizen science experiments on online platforms to help communities better understand how to create safer online spaces, to organizations like Voting Village, a group of computer security researchers, aka hackers, who find flaws in voting machines in order to protect American democracy. For those folks, often what we're doing is providing them with advice on how to minimize their legal risk when they're engaging in work that moves forward the sort of public interest in the space. The sort of last category of stuff I would sort of talk about as doing public interest technology law work is kind of defending individual folks who are facing potential legal challenges to sort of things like their online speech. So this can include things like we co-counseled with the ACLU of Texas working on an issue involving a school district restricting or legally threatening parents for using a version of the logo that had a rainbow flag, the school district logo that had a rainbow flag in it. We've done things like defending on pseudonymous speakers online against potential subpoenas in as parts of civil litigation. And most recently, we've been litigating a case on behalf of Autostraddle, a small indie queer website, one of the few actually sort of remaining queer women and non-binary focused media, independent media organizations who got sued by a copyright troll. So, the sort of thing about all of those categories of work is it's less about sort of, oh, I have a vision of technology policy that I sort of necessarily want to see in the world, but more about how do I serve as an attorney the communities who have a vision of the public interest, and whether the law is either getting in their way or threatening them, or whether they need to use legal law reform in order to attempt their goals that allows them to better do what they want to do while we sort of help them accomplish it as attorneys. So that's kind of how I see the Cyberlaw Clinic's public interest work, less of a sort of broad vision of what we necessarily want the space to look like, although certainly I think individual attorneys may have those views, and certainly I do, but more about how do we align, sort of how do we help clients accomplish their goals towards a sort of better version of technology law and like a better future.